something is breaking down inside the United States Department of Justice, and it is breaking down in a way the American people deserve to understand, not through spin, not through talking points, but through the documented record of federal judges, sworn testimony, and court orders that have now accumulated into one of the most alarming patterns in the modern history of American law enforcement. This is not a drill. What has unfolded over the past 18 months inside the nation's top law enforcement agency is not a political argument. It is not a matter of interpretation. It is a matter of federal court rulings, plural, handed down by judges appointed by presidents of both parties across multiple circuits in multiple states, all arriving at the same conclusion that the Attorney General of the United States, Pam Bondi, repeatedly installed federal prosecutors in ways that violated the Constitution of the United States and the laws passed by Congress. Let that sink in. The chief law enforcement officer of this country was found, again and again, to have broken the law in her very selection of the people tasked with enforcing it. And when judges issued orders in response, orders with real, immediate legal consequences, the administration's response was not correction, not contrition, not a straightforward compliance with the rule of law. It was defiance. It was a memo calling federal judges unelected usurpers. It was public statements attacking the judiciary. It was a pattern that the American Bar Association, in a March 2026 report, described in terms most attorneys have never used in a professional publication. The numbers don't lie. By January 2026, federal judges had ruled against Bondi's U.S. attorney appointments at least 5 separate times. 5. In New Jersey, in Virginia, in New York's Northern District, in Nevada, in California, judges across the country, in rulings totaling hundreds of pages of legal analysis, found that the Attorney General had violated federal appointment law and, in several instances, the Appointments Clause of the Constitution itself. By August 2026, that number had grown further as appellate courts, including the Second Circuit and the Ninth Circuit, affirmed the district court findings. These are not close calls. These are not legal technicalities cooked up by activist judges, as some in the administration have suggested. The Appointments Clause is among the most carefully designed structural safeguards in the entire Constitution. The framers put it there deliberately, because they understood from hard experience what happens when the executive branch controls both the power to prosecute and the power to select, without limit, the prosecutors who will carry out those prosecutions. They understood that such a system is not a justice system at all. It is a tool of personal power. And here is where the story gets genuinely alarming in ways that cut across ideology and party affiliation. What has been documented in these federal courts is not simply a series of paperwork errors. What has been documented is a pattern, in district after district. The administration removed career prosecutors or Senate-confirmed officials, installed political loyalists through administrative maneuvers designed to circumvent the Senate confirmation process, and then used those loyalists to pursue investigations and indictments against people the president had publicly named as his political enemies. Judges threw out the indictments. Not because the underlying allegations were necessarily false, judges were not ruling on the merits in most cases, but because the very prosecutors who brought the cases had no legal authority to bring them. Think about that for a moment. Criminal cases with real defendants, real charges, real consequences for real people were dismissed not on the facts, but because the government's own attorneys were found to be serving illegally. This is the story of what happened to the United States Department of Justice between January 2025 and the summer of 2026. And if you believe, as the founders believed, as every generation of Americans has at least professed to believe, that no person is above the law, and that the law must apply equally to the powerful and the powerless, then this story matters. It matters enormously. If you find this kind of deep, sourced, documented reporting valuable, please take a moment to subscribe, hit the notification bell, because in times like these, independent analysis grounded in actual court documents and factual reporting is more important than ever. The algorithm does not always surface the most important stories, but your subscription does. Now let us go back to the beginning to understand how we got here, why it matters, and what it means for every American who ever believed that when they walked into a federal courthouse, justice was the point. The Department of Justice was created by Congress in 1870. For a century and a half, through wars and depressions and civil rights upheavals and presidential scandals, a fundamental principle has held: while the Attorney General serves at the pleasure of the President, the prosecutorial power of the United States government must not become the personal instrument of whoever sits in the Oval Office. That principle was tested during Watergate. It was tested during the Saturday Night Massacre of October 20th, 1973, when President Richard Nixon ordered the firing of Special Prosecutor Archibald Cox, and two senior Justice Department officials resigned rather than carry out that order. The nation recoiled. 2 years later, Nixon resigned in disgrace. That principle was tested again in 2017. When President Trump fired FBI Director James Comey and later suggested publicly that the Russia investigation was the reason, the backlash was swift. A special counsel was appointed. The norm, battered, held. What has happened since January 2025 is something different in kind, not just degree. It is not a single dramatic moment, a Saturday Night Massacre moment, but rather a sustained, systematic restructuring of the relationship between prosecutorial power and executive will. It has been accomplished not through one bold act, but through dozens of quiet ones: personnel changes, administrative reinterpretations, end runs around the Senate confirmation process, and the deployment of federal prosecutorial resources against individuals the president has named publicly as his adversaries. Here is what nobody is talking about in the mainstream conversation about these events: the constitutional mechanism that ultimately stopped, or at least slowed, this pattern was not Congress. Congress, controlled by the president's party in both chambers, conducted no meaningful oversight of these appointment irregularities for the first year and a half. It was not the Inspector General, whose independence had been undermined early in the administration. It was not the Office of Legal Counsel, traditionally the conscience of the executive branch on matters of constitutional law. It was the federal judiciary, the third branch, the one the administration publicly attacked and privately attempted to ignore. And the judiciary held. On March 9, 2026, U.S. District Judge Matthew Brann issued a 130-page ruling disqualifying the three-attorney leadership structure, what reporters called the triumvirate, that Bondi had installed to run the U.S. Attorney's Office in New Jersey. Judge Brann, a George W. Bush appointee, found that the arrangement violated the Appointments Clause of the Constitution and exceeded Bondi's authority under federal law. In language that was remarkable for its directness, the judge wrote, "1 year into this administration, it is plain that President Trump and his top aides have chafed at the limits on their power set forth by law and the Constitution." He warned that any further attempts to unlawfully fill the office would result in the dismissal of pending criminal cases. Let that sink in. A federal judge appointed by a Republican president wrote, in a published legal opinion, that the administration had chafed at constitutional limits, and then threatened to dismiss criminal indictments if the defiance continued. The backstory in New Jersey is itself extraordinary. The administration had originally installed Alina Habba, Trump's personal attorney and one of his most prominent public defenders, as interim U.S. Attorney for New Jersey in March 2025. Federal law limits interim U.S. attorneys to 120-day terms without Senate confirmation. When that period expired and Haba had not been confirmed, rather than seeking Senate approval or allowing the court to fill the vacancy as provided by law, Bondi devised the three-attorney triumvirate structure. The Third U.S. Circuit Court of Appeals affirmed Judge Brand's original disqualification of Haba. Then Judge Brand struck down the triumvirate as equally unlawful. The administration was, in the court's assessment, engineering around the law at every turn. That pattern repeated across the country with striking consistency. In January 2026, U.S. District Judge Lorna Schofield, an Obama appointee, ruled that John Sarcone, the acting U.S. Attorney for the Northern District of New York, had been unlawfully appointed. Judge Schofield's ruling was the fifth such judicial decision against a Bondi appointment. In her ruling, she wrote, "When the executive branch of government skirts restraints put in place by Congress and then uses that power to subject political adversaries to criminal investigations, it acts without lawful authority. The numbers don't lie." By January 2026, 5 separate federal judges had invalidated 5 separate Bondi appointments. By August 2026, both the Second and Ninth Circuits had affirmed those rulings on appeal. The Second Circuit quashed subpoenas issued by Sarcone's office against New York Attorney General Letitia James because of his unlawful appointment, subpoenas that were part of a federal investigation into James, a Democrat who had previously sued the president. The Ninth Circuit barred Sigal Shatta, Bondi's hand-picked appointee in Nevada, from supervising prosecutions, finding that Bondi's maneuvers to keep Shatta in place remained unlawful under the Federal Vacancies Reform Act. And folks, this is where it gets really concerning. These were not random appointment disputes. These were appointment disputes that directly implicated who was being prosecuted and why. The federal charges against former FBI Director James Comey, brought in September 2025, based on allegations that he had made false statements to Congress, were dismissed by a federal judge on the grounds that the prosecutor who brought them, Lindsay Halligan, had not been lawfully appointed. The indictment of New York Attorney General Letitia James was similarly tainted by the unlawful appointment of Sarcone, who had issued grand jury subpoenas as part of that investigation. Both Comey and James are prominent Trump critics. Both faced federal criminal proceedings. Both saw those proceedings unravel, at least in part, because the prosecutors pursuing them had no legal authority to do so. Constitutional law scholars have noted for years that the Appointments Clause exists precisely to prevent this kind of structural corruption of the prosecutorial process. The clause requires that principal officers of the United States, including U.S. attorneys, be nominated by the President and confirmed by the Senate. The Senate confirmation process is not a bureaucratic inconvenience. It is a constitutional check designed to ensure that the prosecutors wielding the full coercive power of the federal government have been vetted by a body that represents the American public rather than merely the incumbent president. The American Bar Association, in a March 2026 article titled "Democracy Imperiled: Confronting Threats to Judicial Independence," documented the scope of the problem. The ABA noted that Chief Justice John G. Roberts, Jr. had acknowledged in his 2024 year-end report on the federal judiciary the extraordinary pressures on the courts, and that the situation had worsened significantly since then. The ABA's report described attacks on federal judges coming not from ordinary disappointed litigants but from senior public officials, including, the report noted, the Deputy Attorney General, who called for war with the judiciary, and Bondi herself, who publicly criticized the judges who found her New Jersey appointments unlawful. The Brennan Center for Justice cataloged the dismantling of DOJ's internal accountability mechanisms, the checks within the department itself that, in prior administrations, would have flagged these appointment irregularities before they resulted in court rulings. The Inspector General's independence had been curtailed. The Office of Legal Counsel's traditional role as a constitutional check had been diminished. A November 2025 report by Just Security documented numerous instances of judicial criticism of government lawyers in active cases. The pattern that emerges from these reports is not one of isolated errors. It is a picture of a department operating under the assumption that the rules do not apply, and discovering, repeatedly, that courts disagree. The Jenner and Block episode offers a particularly vivid illustration of the administration's posture toward judicial authority. In April 2025, after a federal judge partially blocked enforcement of an executive order targeting the law firm, Bondi and Office of Management and Budget Director Russell Vaught jointly issued a memo that was required by the court to be sent to all executive branch agencies. That memo, filed in court records, opened with a denunciation of the ruling. It called the judge unelected and accused the court of engaging in a blatant overstepping of the judicial power. It simultaneously told agencies they were permitted to carry on ordinary business, language widely read as a signal that agencies could continue avoiding the law firms despite the court order. Legal scholars described the memo as extraordinary. An attorney general using court-mandated compliance documents as a vehicle to publicly attack the court that issued the order is, to put it plainly, without modern precedent. I want to be clear. The concern here is not partisan. The Justice Department's independence from direct presidential control over individual prosecutorial decisions has been defended by Republican and Democratic attorneys general alike for decades. It is a norm that has been upheld through Republican and Democratic administrations. Former Republican Attorney General Alberto Gonzales, who himself faced criticism over the firing of 9 U.S. attorneys in 2006, nevertheless operated within a framework that treated the Senate confirmation requirement as a genuine constraint. The Trump administration's approach has been different, not just in degree, but in kind. If this analysis is helping you understand what is actually happening in our federal courts, beyond the noise and the spin, please consider subscribing and sharing this video with someone you trust. Drop a comment below telling us what aspect of this story concerns you most. We read every comment. Here is the part of this story that tends to get lost in the legal technicalities, the real, concrete consequences for real people. Because while the constitutional violations are serious in the abstract, they become even more serious when you trace their effects down to what they mean for ordinary Americans who interact with the federal justice system. Consider what happened to the defendants in the New Jersey cases. When Judge Brand disqualified the triumvirate in March 2026, hundreds of federal criminal cases were placed in immediate legal jeopardy. Criminal defense attorneys in New Jersey had been warning since July 2025, when the Haba controversy was at its peak, that the appointment problems put potentially hundreds of cases at risk. Every indictment, every plea agreement, every grand jury subpoena issued under the authority of an unlawfully appointed U.S. attorney is potentially compromised. Defendants who may be guilty of serious crimes may walk free, not because they were exonerated, but because the government broke the law in pursuing them. That is not a minor bureaucratic problem. That is a failure of justice for victims, for communities, for the integrity of the entire system. And consider the opposite problem. What about the cases where the prosecutorial targeting was politically motivated? What about the individuals who found themselves facing federal charges brought by prosecutors who were installed specifically because they were loyal to a president who had publicly named those individuals as his enemies? For those defendants, Comey, James, and potentially others, the constitutional violations were not just procedural abstractions. They were the mechanism through which the coercive power of the United States government was deployed against them for reasons that had nothing to do with justice and everything to do with politics. This is why the framers wrote the Appointments Clause. This is why the Senate confirmation requirement exists. This is why the independence of the Justice Department from direct White House control over individual prosecutions is not just a nice norm, but a structural necessity. When that independence collapses, the justice system becomes something else entirely. a tool of whoever holds the presidency, pointed at whoever the president wants to punish, and shielded from whoever the president wants to protect. The cascading implications extend well beyond the individual cases that have already been decided. As of August 2026, questions remain about the legal validity of actions taken by other Bondi appointees who have not yet been specifically challenged in court. Every search warrant, every grand jury subpoena, every indictment issued under questionable appointment authority carries with it the potential for future legal challenge. Prosecutors trying to secure convictions in those cases now carry the burden of demonstrating that their authority was valid, a burden that in several districts, courts have already found they cannot meet. There is also the question of what this pattern has done to the morale and institutional health of the Department of Justice itself. Career prosecutors, men and women who devoted their professional lives to the nonpartisan enforcement of federal law, watched as political loyalists without their experience or track record were installed above them. Some resigned. Danielle Sassoon, a federal prosecutor in New York, resigned and wrote a letter to Bondi explaining that conditions within the department made it impossible for her to do her job. She was not alone. The GovFacts reporting from February 2026 noted that dozens of career prosecutors had raised concerns about the administration's direction, citing evidence that prosecutorial decisions were being made based on the president's political preferences rather than the evidence. What does it mean for an institution when its own members conclude that the mission has changed, that the department is no longer oriented toward impartial justice, but toward political loyalty? What does it cost in institutional memory, in professional expertise, in the accumulated knowledge of how to bring complex cases ethically and effectively when experienced career prosecutors walk out the door and are replaced by political allies? The answer is, it costs a great deal. And those costs are not felt in the Oval Office or the main Justice Building. They are felt in courtrooms across the country, where cases collapse, where guilty people go free because the government cannot make its case legally, and where innocent people face the full weight of the federal government for reasons that have nothing to do with justice. And folks, this is where it gets really concerning, because the judicial check, the one institution that has consistently held the line in this period, is itself under sustained attack. The Abbas March 2026 report noted that members of Congress had called for the impeachment of at least 6 federal judges who ruled against the president's agenda. The administration filed a lawsuit against all 15 federal judges in Maryland over a deportation order. The administration's own memos described district court judges as overstepping their authority and called on the Supreme Court to rein them in. Federal judges have faced not just political attacks, but physical threats. The Abbas report noted that their efforts to uphold the law have been met with dangerous and unrelenting attacks on judges' legitimacy and their physical safety. This is not hyperbole. Federal security services have documented an increase in threats against members of the judiciary during this period. What happens when the institution doing the checking is itself delegitimized, defunded, or intimidated into deference? What happens when judges aware that their decisions will trigger public attacks from the Attorney General, calls for their impeachment from members of Congress, and threats to their personal safety begin to internalize those pressures? The rule of law does not disappear in a single dramatic moment. It erodes. It is chipped away, ruling by ruling, norm by norm, until the system that remains bears little resemblance to the one the founders designed. The Protect Democracy Project, in its analysis of the administration's conflict with the courts, identified a pattern it calls legalistic noncompliance, the use of legal language and formal procedures to mask the defiance of court orders happening behind closed doors. The administration says the right words, files the right documents, and simultaneously signals to the agencies it controls that the courts can be ignored. It is, the analysis concluded, a strategy of eroding constitutional checks one slice of the salami at a time, incrementally, just beneath the threshold that would trigger a decisive public or institutional response. That strategy appeared in perhaps its starkest form in the Jenner and Block episode, when Judge Bates issued his temporary restraining order and required Bondi and Vout to send a compliance memo to all executive branch agencies. The memo they sent simultaneously denounced the judge's authority and told agencies they could still choose not to work with the law firms. It complied with the letter of the order while hollowing out its substance. And it did so in a document that would itself be filed in court, a public declaration that the administration's compliance was reluctant at best and performative at worst. A nation that prides itself on being governed by laws, not men, a phrase that stretches back through John Adams to Aristotle, must grapple honestly with what it means when the chief law enforcement officer of the land openly contests the authority of the courts to enforce the law. It is not a comfortable grappling. It should not be a comfortable grappling. It is the kind of reckoning that this nation has historically managed to navigate through the courts, through elections, through the slow grinding process of institutional accountability, but only when enough people were paying attention. There is a particular kind of heartbreak that comes from watching an institution you believed in fail in ways you were always told it could not fail. For generations of Americans who grew up believing that the Department of Justice was, whatever its imperfections, ultimately oriented toward the equal application of the law, for civil rights lawyers who appealed to it, for whistleblowers who trusted it, for immigrants who sought its protection, for crime victims who depended on it. The events of the past year and a half have delivered a kind of civic grief. This is not a grief born of naivety. Many of those same Americans know, and have always known, that the DOJ has a complicated history. They know about COINTELPRO and the surveillance of civil rights leaders. They know about the Japanese-American internment cases where the Justice Department failed utterly. They know about the periods of politically motivated prosecution and the long struggle to build the norms of independence that came painfully out of those failures. But they also know that those norms were built precisely because the failures were recognized as failures, because subsequent generations looked back and said, "That was wrong, and we must build something more durable." That reckoning, that capacity for institutional self-correction, is itself a form of democratic health. I want to be clear. What is at stake in the story of Pam Bondi's tenure at the Justice Department is not a partisan argument about which party is better at enforcing the law. It is something more fundamental. It is a question about whether the executive branch of the United States government believes it is bound by the same constitutional constraints as every other institution and every other citizen. It is a question about whether the Senate's constitutional role in confirming principal officers is a genuine check or a formality to be circumvented whenever it proves inconvenient. It is a question about whether the courts have the authority to say no to the government and whether that authority will be respected. The federal courts have said no, repeatedly. Judges appointed by George W. Bush, Barack Obama, George W. Bush again, a Hawaii-based Bush appointee, an Obama appointee in New York, a Clinton appointee in Virginia, have all looked at Bondi's appointment decisions and reached the same conclusion: they violate the law. The Ninth Circuit, the Second Circuit, the Third Circuit, multiple appellate courts have affirmed those conclusions. This is not a regional aberration or an ideological quirk. It is a consistent finding across the judiciary. And yet the administration has contested those findings at every turn, continued to push the same strategies that courts have repeatedly rejected, and simultaneously attacked the legitimacy of the courts issuing those rulings. Here is what nobody is talking about clearly enough, what the administration's behavior reveals about its underlying theory of executive power. The position that Bondi and the broader administration have effectively taken in memos, in public statements, in legal filings, is that the president's power over the executive branch is essentially unlimited. that Senate confirmation requirements are obstacles to be engineered around rather than constitutional constraints to be respected, and that courts which disagree with the executive's interpretation of its own authority are overstepping their bounds. This is a coherent theory of presidential power. It has defenders in legal academia, most prominently among proponents of the unitary executive doctrine. But it is a theory that courts have, in case after case, declined to adopt, because the Constitution's text, its structure, and 2.5 centuries of precedent point in a different direction. The Appointments Clause says what it says. The Federal Vacancies Reform Act says what it says. The 120-day limits on interim appointments say what they say. These are not ambiguous provisions open to creative reinterpretation. They are specific, explicit constraints that Congress enacted and that presidents before Trump, including presidents who chafed at those constraints, ultimately complied with. The cost of noncompliance has already been made visible in the cases that collapsed. The indictment of James Comey, dismissed. The subpoenas against Letitia James, quashed. Indictments in New Jersey, threatened with dismissal. Federal cases in Los Angeles, Nevada, and New York's Northern District, potentially compromised. The people who brought those cases, the alleged victims of whatever Comey or James or others may or may not have done, deserve a justice system that functions within the law. They have been failed by an administration that prioritized political loyalty over legal competence. But the costs extend beyond the specific cases. They extend to what has happened to the institutional culture of the Justice Department itself. The men and women who remain, the career attorneys who have not resigned, who show up every day to do the work of federal prosecution across the country, carry with them the knowledge that their institution has been repeatedly found to have broken the law in its appointments. That is a weight on the institution's credibility, in courtrooms, in communities, in the eyes of the international legal community that has long looked to the United States Department of Justice as a model for prosecutorial independence. There is a phrase, perhaps overused, perhaps undervalued, that captures what is being described here: the rule of law. It is not an abstraction. It is a practice. It is the daily, accumulated choice of institutions and individuals to be bound by rules they did not write, enforced by courts they did not appoint, applicable even when inconvenient, even when the powerful would prefer otherwise. The rule of law is what distinguishes a justice system from a power system. And it is upheld not by declarations or slogans, but by the willingness of those in authority to accept, when a court says no, that no means no. That willingness has been conspicuously absent from the conduct documented in this story. The founders of this country were not naive about power. They had lived under a monarchy. They had experienced firsthand what it felt like when the executive authority of the Crown used its control over courts, over prosecutions, over the appointment of officials to punish its enemies and protect its friends. They designed a constitutional system specifically to prevent that pattern from reasserting itself in the republic they were building. The Appointments Clause was part of that design. The separation of powers was part of that design. The independence of the judiciary was part of that design. When a U.S. Attorney General publicly attacks an unelected judge for enforcing the law, the irony should not be lost on anyone. Federal judges are, by design, appointed rather than elected, precisely so that they cannot be removed by popular pressure, precisely so that they can uphold the law even when the law is unpopular with the powerful. That design is a feature, not a bug. It is what allows a judge to say no to a president without fear of being voted out of office for doing so. It is what allowed Judge Brand to write his 130-page ruling. It is what allowed Judge Schofield to quash the Letitia James subpoenas. It is what has allowed the appellate courts to affirm again and again that the law applies to everyone. The disappointed patriotism that frames this story is not despair. It is not the despair of people who believe the system has failed beyond recovery. It is the disappointment of people who believe deeply enough in the system to be genuinely grieved when those entrusted with its maintenance choose to treat it as an obstacle rather than a foundation. It is the disappointment of Americans who remember, who were taught to believe, that the Department of Justice belongs to the people, not to the president. That when a federal prosecutor walks into a courtroom and invokes the authority of the United States government, that authority is borrowed from 340 million citizens, not granted by one man in the Oval Office. That the power to prosecute is the most coercive power the government exercises over individuals, and that its exercise must be constrained, checked, and accountable. Not because prosecutors cannot be trusted, but because unchecked power corrupts, and the founders knew it. What does accountability look like in this moment? It looks like what has already happened: courts doing their job, even under pressure. It looks like the Third Circuit affirming Brand's ruling, the Second Circuit quashing unlawful subpoenas, the Ninth Circuit unanimously finding that the administration's tactics could not keep an unlawful appointment in place. It looks like the American Bar Association publishing a report that uses words like democracy imperiled in its title, words that lawyers do not use lightly. It also looks like attention. It looks like citizens, particularly citizens who remember a different era, who came of age when Watergate showed what it meant for a president to weaponize the Justice Department, who remember the institutional reckoning that followed, engaging with what is actually happening in these courtrooms, beyond the noise of social media and partisan punditry. The numbers tell the story. 5 unlawful appointments found by district courts as of January 2026. Multiple appellate affirmances by August 2026. Criminal indictments dismissed. Grand jury subpoenas quashed. A 130-page ruling warning that further defiance would cost the government its own criminal cases. A federal judge in Hawaii, appointed by a Republican president, writing that the administration had violated federal appointment law in Los Angeles. A federal judge in New Jersey, also a Republican appointee, warning that the administration had repeatedly and plainly chafed at constitutional limits. These are not the words of ideological opponents. These are the findings of judges across the political spectrum, across geographic regions, across the federal court system. And they add up to a picture that Americans of conscience, whatever their politics, should look at honestly. This is not a drill. It has never been a drill. The Appointments Clause is not a drill. The Federal Vacancies Reform Act is not a drill. The requirement that principal officers of the United States be confirmed by the Senate before wielding the coercive power of the federal government is not a drill. It is the law. And the story of the past year and a half is the story of what happens when the people responsible for enforcing the law treat it as optional. The good news, and there is good news in this story, is that the system has not been silent. The courts have spoken, clearly and consistently. The legal profession has spoken, through Bar Association reports and law review articles and court filings that document the pattern with precision. The career prosecutors who resigned spoke, through resignation letters that put their professional reputations behind their concerns. The democratic process will also speak, through elections and congressional oversight and the ongoing accountability that a free press and an engaged citizenry make possible. But that accountability requires attention. It requires the kind of sustained engagement with complex, documented reality that is harder than a headline and more important than a tweet. It requires people who remember and who care enough about what they remember to keep watching, keep reading, keep asking the question that every generation of Americans has had to ask: is this still a nation of laws? The answer, if the courts are any guide, is that the law has fought back. The answer, if the documented record is any guide, is that the constitutional structure has bent under this pressure but has not broken. The answer, if the history of American democracy is any guide, is that moments like this one, Moments when the executive tests the limits of its power and the judiciary pushes back are not the end of the story. They are a chapter. And what comes next depends, as it always has, on whether enough Americans are paying attention. So pay attention. Share this video with someone who needs to understand what has actually been happening in federal courtrooms across this country. Drop a comment below. Tell this community what you think the most important lesson of this moment is. Tell us what gives you hope, what gives you concern, and what you think the next chapter should look like. This conversation matters. This community matters. And in times like these, so does your voice. The law has not given up, and neither should we.